A nominee before the committee told us about the shortage of even justices. With the commissioning of new courts and all that, we'll need more judges. There is also evidence that if you go to almost all our municipal district assemblies, we don't have lawyers. If you look at even the regional distribution of lawyers in Ghana. However, admissions to the law school has always been a problem, and we know that the biggest challenge is access and maybe some form of regulation. My question borders on how the General Legal Council addresses those matters. We understand the challenge, but the manner in which the challenge must be addressed must be fair, it must be candid, and it must comply with all the rules under Article 296, for example, in the exercise of discretionary powers. Coming from a background where you've done even articles on fair trial and all that, would you consider the General Legal Council's directives on undertaking by law students who are taking entrance exams with respect to not having a right to demand either remarking, to see their papers, and so on and so forth? Would you consider those directives as a bit arbitrary and a little bit, contrary to, would that amount to wrongful exercise of discretion in your view?
Thank you, Honorable Chair, for the question. Now, once you mentioned the law school, perhaps I have to, state a bit of the history of the law school. I'm sure most of us know that the law school was established in 1958. And that around that time, as the first advert for interested persons to apply, attracted about 927 persons. They applied. Out of the 927 persons, 98, after they have been subjected to interviews and what have you, 98 gained admission to the law school. And out of the 98, only 9 were called to the bar that year. That was in 1958. Only 9, and I'm perhaps glad to say that one of the 9 taught me at law school. And so it has been a problem from even the very beginning of the establishment of the law school up to today. Because yes, our people, Ghanaians, like you and I, have desired to have legal education. But because of lack of space, at least as a lecturer, I can speak to that fact. And since 1958, we have not added to the structures of the law school. And so yes, if we want to address that problem, I think we need to take a critical look at the structures, the classroom facilities which are available. Now, perhaps you'll be very surprised to hear, and once you are a member, perhaps I will not land myself in so much trouble by saying that last year, because the House decided that certain students must be admitted, the law school went and rented an accommodation at Lowdown, and they were paying about 6,000 Ghana cedis a day, when they don't earn 6,000 Ghana cedis a day. So back to what I was saying, that we need to take a critical look as a nation at the infrastructure which is available to the law school. And once we address that problem, then I believe we will be making a headway. As for the measures which have been introduced by the General Legal Council in respect of whether a student has a right to ask for remarking or what have you, that does not stop any student, in my view, from going to court to seek redress. Thank you.